started. Thanks to everybody for introducing themselves. Keep them coming. But for the sake of time, we will kick things off. For those I don't already know or who haven't been here for the last 4 sessions, my name is Molly Coleman, and I'm the Executive Director of People's Parity Project, where we are organizing lawyers and law students to unrig the law and build a legal system that works for working people, not just corporate power. We at PPP are very proud to be organizing this reading group in collaboration with the Law and Political Economy Project, and are stoked to welcome you to session 5 of What to Do About the Courts. Most of you have been here before, so I'm going to keep our logistical overview pretty short. We are going to start tonight by hearing from Professor Ryan Doerfler, who Corinne will introduce to you in more depth in just a minute. Once Professor Doerfler's remarks conclude, you all know where you're going. If you are participating in an in-person discussion, feel free to log off and join that conversation IRL. If you are in an independent Zoom discussion group, totally fine. Jump off Zoom when this ends and head over to that Zoom link. And then if you stay on, we'll assume that you intend to participate in our virtual discussion group. You'll get sent to those rooms a minute or two after Professor Doerfler wraps up, and then the breakout rooms will remain open until 9:30 Eastern Time. I'm going to drop 2 items in the chat once I'm done talking. The first is the list of discussion questions. You already should have those. You got them over email last week, but good to have them readily at hand. The second is a short feedback form. It's the same feedback form we've used the last 4 times. We really, really appreciate those who continue to take a minute to fill that out. Again, this is a full experiment. We're really trying to make adjustments in real time to make this a good experience for everybody. So thank you for filling that out. We ask you to do it one more time. And that is it on the logistics front. If you have any questions, feel free to drop them in the chat, logistical questions. And with that, I will hand things over to Corinne.
Awesome. Thanks so much, Molly. I'm Corinne Blaylock. I'm the Executive Director of the Law and Political Economy, or LPE project, which is a network of legal scholars, students, and practitioners developing scholarship and pedagogy to democratize our political economy, build people power towards a more just, equal, and sustainable future. But tonight, it is my privilege to introduce Professor Ryan Doerfler. Ryan Doerfler is professor of law at Harvard Law School. His research focuses on the role of the judiciary within a democratic system. His recent work includes a critical reassessment of the embrace of judicial review within the liberal legal tradition, and an analysis of the relationship between theories of statutory interpretation and the commitment to democratic self-rule. He's written a number of scholarly articles with Professor Sam Moyne, one of which you all read for tonight's session. And finally, Professor Doerfler has helped popularize these ideas with contributions on the problems with juristocracy and what we can do about it in publications including Dissent, The Atlantic, and The Nation, among others. And now, without further ado, I will turn things over to Ryan so we can get started.
Thanks so much, Corinne, and thanks, Molly, and everyone else for coming. Just share my slides. Great. Okay. So thanks so much again for coming. So if you're here, it is very likely that you are upset about people like this or like this, and the sort of devastation that they are causing in their position as Supreme Court Justice. But as the title of this reading group suggests, the question is what to do. Right? What is the most sort of feasible, efficacious, strategic response to the current Supreme Court? Now, one straightforward response that I'm sure all of you have thought about at great length already is to load up the Supreme Court with different people, right? Adding more people like this, or if you're more ambitious, maybe even people like this. And of course, through various mechanisms. Most obviously, probably the idea of court expansion is familiar to most of you, or court packing, as it's sometimes called, or maybe through mechanisms like term limits or something else, right? But whatever the mechanism, the idea would be one immediate response to this terrible Supreme Court would be to change the composition, change the ideological composition of that entity. And as you know from the article that you perused for this session, Sam Moyne and I refer to these sorts of approaches, these sorts of reforms, as personnel reforms, right? And so personnel reforms are, as the name suggests, reforms tailored or intended to alter the personnel or ideological composition of the court, shift the ideological composition to the left, or shift it in a more democratic, small d democratic direction. But either way, it's just change the sort of outputs that the court delivers by changing the character of its personnel. Now, adopting those sorts of personnel reforms, right, whether it's court expansion or term limits or what have you, I think all of these things would be good things, right? These would be beneficial changes to the court. However, as I think it was covered in greater length in previous sessions, history suggests that although these sorts of personnel reforms would be good, the serious worry is that they would not be good enough, right? That in fact, to merely limit our response to the current Supreme Court to personnel reforms would be a grievous mistake. And here, maybe the clearest example is the historical example of FDR, right? Sort of famous court confrontation with the Supreme Court in the 1930s, threat of court expansion, threat of court packing, although that threat of court packing fails through a series of events. We do see, in effect, the ideological composition of the court change in relatively short order through a series of retirements and appointments. And in the near term, that conflict, right, that conflict with President Roosevelt and the subsequent ideological change of the court did lead to, at least comparatively, good results, right? You had the Warren Court era where at least, broadly speaking, the Supreme Court was at least a modest source of justice rather than reaction. However, in relatively short order, at least in terms of the history of the country, through a series of later changes in personnel, we see the court shift back to its historical role of basically a source of reaction, right? And again, this is covered at greater length in earlier sessions, but just to remember that, again, that insofar as the primary approach or the result of the conflict between the court and FDR in the 1930s was this sort of personnel reform, right? Changing the ideological character of that body. The ultimate effect was a sort of very brief period of modestly attractive outcomes, followed by decades upon decades of quite reactionary ones. Okay, and so in that sense, again, I think the basic historical lesson of that conflict was that in the 1930s should really be thought of as a lost opportunity. Okay, but then the question becomes, okay, well, opportunity to do what, right? What would have been a better use of that conflict? And the short answer to that is that as Sam and I argue in our piece and in various places, a much more promising, much more sort of long-lasting approach to judicial reform would be one that falls under this heading of disempowerment, right? The goal is rather than changing the composition or ideological orientation of the court to actually just either curb or outright eliminate the authority that the Supreme Court in particular and that federal courts in general enjoy. And here the idea is a relatively straightforward one, right? Rather than allow ourselves to be ruled by philosopher kings, whether benevolent or malign, we should instead strip those philosopher kings of their authority and instead prefer democratic self-rule. Now, here I want to talk about more specifically sort of three specific disempowering reforms. I'm going to talk about a legislative override, two, the imposition of a supermajority requirement, and three, the use of so-called jurisdiction stripping provisions. Before I get into those specifics, though, which is the bulk of the discussion here, I do want to flag at the outset that thinking about the relationship between those disempowering reforms and those earlier reforms that I mentioned, personnel reforms, is something that I want to come back to towards the end, both as a theoretical matter to think about how the two relate to one another, but also politically, right? To ask, like, how should we, as a political matter, how should we understand the relationship between personnel reforms, which again, I think are best characterized as good, but not good enough, and the sort of more fundamental reforms that again fall under this heading of disempowerment. Okay. And so then to move on to the specifics. So let's start with the idea of a legislative override. Okay. And so what is that? What is a legislative override? The basic idea here is that Congress would, and in this case, I'll say all of the reforms that we're proposing, we at least argue could be adopted by ordinary legislation, right? So none of the reforms that we're talking about here would require formal constitutional amendment. As a political matter, Sam and I thought that this was an important site constraint to place on our reform project. And so here, insofar as we are imagining the implementation of a legislative override, this would just be an ordinary statute that Congress adopts that says we can override a Supreme Court decision, let's say declaring some statute unconstitutional. That's the basic mechanism. Again, so a Supreme Court or a court would retain the authority to weigh in, for example, on the constitutionality of ordinary legislation, but Congress would then in turn assert its right to overturn or negate the Supreme Court's decision insofar as Congress disagreed with it. Now, sometimes this approach to sort of interacting or curbing judicial authority goes under the heading of a dialogic approach to judicial review, right? And the idea here being that by having a legislative override come after a judicial ruling on, let's say, the constitutionality of ordinary legislation, that puts the court and Congress into dialogue about what the Constitution means, right? So rather than one entity or the other claiming ultimate authority, this legislative override model would put these two entities more on par with one another. Now, as a practical matter or as a historical matter, other countries do adopt this sort of legislative override mechanism, right? The nearest and most familiar to many of us is Canada, whose constitution contains the so-called notwithstanding clause, which allows Parliament or the legislature of any province to expressly declare that some piece of legislation shall be enforced, notwithstanding an adverse judicial decision. Now, notably, the notwithstanding clause in the Canadian Constitution limits the practical effect of that legislative override or parliamentary override to 5 years, right? So if the Supreme Court declares an act of Parliament at odds with the Canadian Constitution, Parliament can override that decision, but that overriding will only last for 5 years, and unless Parliament acts again, then the piece of legislation would go out of effect. Okay, so that's one just historical example of a legislative override in our neighboring country. Now, if we were trying to think about what would this look like in the U.S., right? What would it look like for Congress to adopt a legislative override statute? Here we would imagine, and again, this idea that just through ordinary legislation, Congress would assert its right to, in effect, reenact legislative provisions or statutes entirely that have been declared by either the Supreme Court or any court whatsoever, bringing those legislative provisions or enactments back into effect, notwithstanding those earlier judicial decisions, and again, very plausibly with some sort of sunset provision, right? This idea, again, we are re-upping the Voting Rights Act, let's say, but that re-up only lasts for, again, let's say 5 or 7 years. Okay, so that would be the basic mechanism. Now, as with all of these reforms, there's this basic question. You're like, okay, that sounds like a great idea, but can you do that, right? Is that allowed? Can Congress just go ahead and enact a statute that purports to override Supreme Court decisions? And you might think that here, the answer has to be no, right? So there are a number of Supreme Court decisions, most recently, probably the City of Bernie case, where the Supreme Court reacts quite negatively to efforts by Congress to effectively negate or supplant Supreme Court interpretations of the Constitution. Okay, and so how do you get around the City of Bernie problem? Well, it's a practical matter, and again, we're going to see how these various reforms really interact as a technical matter, even if conceptually we can hold them apart. In practice, I think the best way to get around a City of Bernie problem with a legislative override statute is just to attach to or include as a provision within that statute either. So this idea of jurisdiction stripping, saying that again that by taking this step, Congress implements the Voting Rights Act, negating the Supreme Court's decision. Oh, and by the way, this newly enacted Voting Rights Act is not subject to judicial review, right? That would be one way of insulating that effective override from ultimate judicial obstruction. Or somewhat less aggressively, you might attach a supermajority requirement, saying that, again, Congress, pursuant to the statute, re-ups the Voting Rights Act, and the Supreme Court can only negate that action through the use of a supermajority as opposed to a simple majority. Okay, so that would be the basic mechanics of how a legislative override would work. But again, the basic idea is that, again, courts are permitted to pass on the constitutionality of ordinary legislation, but to the extent that the current Congress disagrees, the current Congress can effectively negate the decision through the ordinary legislative process. Now, again, one question with this sort of statute is to which courts would such an override apply? Would this only be for the Supreme Court? Would this be for federal courts in general, for state courts as well, right? Those are implementation questions that I think are worth mulling over. Before getting into those questions, or just more generally though, I think it's helpful to think about, okay, so what are the pros and cons of this approach? And I should say that I'm sort of working through these three approaches, again, a legislative override, a supermajority requirement, and then a jurisdiction stripping approaches from a sort of like less to most interventionist, right, or least to most aggressive. And so one advantage then of the legislative override model, at least viewed by some, is that it's comparatively modest, right? Again, we're not eliminating the role of the court in terms of interpreting the Constitution, determining which acts of legislation are or are not consistent with the Constitution. Rather, we're merely sort of elevating Congress to being on par with the court. And so again, for some, we might think that that is at least some sort of political advantage insofar as it's the least radical of the reforms here. Similar to the extent that you are persuaded by this dialogic picture, right, that we have multiple actors weighing in on how best to understand the Constitution, we might think that that is another virtue, right? We have multiple people sort of assessing the same document. Perhaps we gain some sort of greater insight by having that plurality of interpreters. Now, on the downside, right, what are the cons to a legislative override? I think one is this, that as a practical matter in places like Canada, in practice, legislative overrides are used quite rarely. Right, so the Canadian Parliament actually invokes the notwithstanding clause relatively rarely. Now, one could tell a story there that perhaps the Canadian Supreme Court is issuing its decisions sort of in the shadow of that notwithstanding clause, right, anticipating that sort of really out of the ordinary decisions might be negated. I think, though, if you think ahead, though, to the United States, I think there is reason to anticipate that, at least under our current institutional arrangement, that a legislative override would be quite rarely invoked, largely owing to the structure of our legislative process, right? That it would be quite difficult for Congress to, in effect, to actually act pursuant to this override mechanism. And the reason is just that, if you think about it, again, suppose that the Supreme Court were to negate some, voting rights legislation. Pursuant to this legislative override statute, Congress would have to continue to have working legislative majorities to, in effect, reenact that statute, right? And there are all kinds of structural reasons why within our bicameral presidential system that it's very hard to put together that sort of trifecta, right, for a single, within the sort of current moment of polarization for, let's say, Democrats to capture, again, the House, the Senate, and the president, right? Unless you have that trifecta, you are not in a position as Democrats to, in effect, negate that Supreme Court decision declaring some piece of voting rights legislation unconstitutional, right? So it's not enough on this model to put together a working legislative majority to enact the statute in the first place, but you have to preserve that majority, right? You have to preserve that majority waiting to respond to hostile sort of responses by the Supreme Court. Now, of course, if you were to alter our legislative process, right, that might change your assessment of the relative efficacy of a legislative override, right? So again, sort of within our current system, again, relatively hard for Congress to make use of this provision. But if we were to get more creative, right, and think about ways to perhaps render our legislative process more democratic, right, perhaps sort of through various approaches, let's say limiting the role of the Senate in the legislative process, making it easier for Congress to enact legislation. Under that regime, something like a legislative override, I think, would become more attractive, right? It would be, in effect, it would be more effective to the extent that we lower the cost or eliminate veto gates to enacting ordinary legislation. So that's just something to think about, right? The way that judicial reforms interact with other potential democratizing reforms to other institutions, whether it's Congress, the president, or some other entity. Okay, so that's on, and then one last sort of downside in terms of the legislative override. And I think this is something to think about more generally. one challenge to the legislative override approach is that it's kind of hard to create constituencies behind that sort of generic reform, right? There's a sort of conventional wisdom in electoral politics that people don't get very excited about process reforms, right? And again, this sort of legislative override mechanism is exactly that, right? It's a process reform. It's not attached to any particular substantive idea or goal that people have that are maybe easier to use to mobilize people. So that's one concern that we should bear in mind. Okay, next, turning to the second option of a supermajority requirement. Now here, as the name suggests, is that, again, under the default rule, the Supreme Court or any Court of Appeals panel can decide a decision, but can issue a decision by a simple majority, right, 5-4 for the current Supreme Court. However, if we look around our legal system, there are other examples of decision rules that are not simple majority rules. So, for example, again, if we go back to the Senate, right, we know the Senate has rather in Congress, under the Constitution, in terms of response to a presidential veto, right? Congress has the power to overcome a presidential veto by a 2/3 vote, right? So that's one familiar supermajority approach, a 2/3 requirement. Another from the criminal context is the unanimity rule that we use for criminal juries, right? Again, the unanimous jury to issue a criminal conviction. So we see within our legal system, again, simple majority rules are a sort of intuitive default, but we see, again, 2/3 rules, unanimity rules appear in various places. Now, with respect to judicial review, right, to evaluating legislation for constitutionality, within our federal system, we do see at least two examples of supermajority requirements that have been adopted by different states. So in the state of Nebraska, for example, by a constitutional, pursuant to a constitutional provision, the Nebraska Supreme Court can only declare an act of legislation by the Nebraska legislature inconsistent with the Nebraska Constitution by a vote of 5 of 7. Similarly, in the state of North Dakota, the North Dakota Supreme Court can only declare a piece of legislation from the North Dakota legislature unconstitutional by a vote of 4-5. Now, both of these provisions were adopted during the progressive era of the 1910s and 1920s, right, in response to the sort of excesses of the Lochner era judiciary. And so maybe that is one sort of hopeful historical analogy that we can draw on in our current moment. Now, in terms of implementation, right, what would it look like, again, for Congress to create a supermajority requirement, at least through ordinary legislation? Again, in Nebraska and North Dakota, these are explicit constitutional provisions. Here, we don't have such a provision, obviously, in the US Constitution, and so Congress would have to do something through statute. And in terms of implementation, in effect, Congress would just pass a statute that said exactly that. Pass a statute that says, let's say, in order to declare an act of Congress unconstitutional, the Supreme Court may do so only by a supermajority. Now, we could ask, either of 6-3, 7-2, up to unanimity, right? So that would be the basic mechanism. Now, again, we have the legal question, though. Okay, so can Congress do this, right? Can Congress just pass a statute that says, okay, going forward, the voting rule isn't 5-4, but rather it's 9-0, right? Is that something that Congress can just do under the current legal regime? And I think, again, the answer, we argue, is yes. And I think here the most helpful piece of legal scholarship on this is an earlier article by Jed Sugarman, called the 6-3 rule, where Jed explores both the history of supermajority requirements, but also offers, I think, the crispest legal theory in terms of how is it that Congress could enact a supermajority rule through ordinary legislation. And the way that Jed describes it is that, in effect, that statute that says the Supreme Court can only declare legislation unconstitutional, let's say by a vote of 6-3, what that provision says, in effect, is that the Supreme Court, insofar as it can't put together a supermajority for that to declare the statute unconstitutional, in effect, the Supreme Court then lacks jurisdiction to decide the case, right? So it's not that the Supreme Court is directed to decide the case in favor of the constitutionality of the statute. Rather, it just says that, look, if you can't put together 6 votes, you actually lack authority to issue a decision either way. And now this way of framing a supermajority requirement, I think it's important in part because it helps to explain this straightforward constitutional hook for a supermajority rule, which I'll come to in just a bit. But in addition, it's response to one of the sort of core objections that we see to this proposal of the supermajority requirement, grounded in this earlier Supreme Court case called the United States against Klein, which I won't go into the details here, but at least one way of interpreting the Supreme Court's decision in Klein is as saying that although Congress can decide whether the Supreme Court or a court in general is allowed to hear a case, what Congress cannot do is tell a court how to decide the case, right? They can't tell the court to decide in favor of the defendant or decide in favor of the plaintiff. Once Congress has given a court jurisdiction to decide a case, the court has to be independent in reaching its conclusion. And so again, insofar as we think of supermajority rules, not as rules of decision so much as rules of jurisdiction, right? Again, in the absence of a supermajority, the court simply lacks the authority to decide the case. I think that helps to avoid any potential Klein problem. Now, in terms of that, so that's the sort of technical or legal justification, but you might ask, okay, so what speaks in favor of this rule, right? What is the basic rationale? Why would I want to adopt a supermajority rule in this context? And I think here, at least one intuition that I think often motivates people to embrace a more disempowering or democratizing approach to judicial reform is the idea that at least in the sort of hard cases, right, the cases that get contested in front of the Supreme Court, let's say, that at least in those cases, there really isn't a lot of law there, right? That in effect, what the court is doing is just deciding, right? What do we want the Constitution to mean? It's not that the court, again, the court will purport to engage, let's say, in an originalist exercise to sift through historical materials to discover the answer of what, the true meaning of equal protection or the true meaning of freedom of speech is. But again, the intuition here is that in most of these cases, really what the court is doing, consciously or no, is simply resolving some under-specified aspect of the Constitution, in effect deciding what freedom of speech, let's say, should be. And so again, insofar as there is no law in those hard cases, there is an intuition that that is a sort of inappropriate space for judicial decision. And this connects with really the traditional conception of judicial review at the founding, where to the extent that judicial review was considered available, it was only available in cases of clear error. This sort of conception of the judicial role was really codified as a theoretical matter by James Bradley Fair, an earlier Harvard law professor. And even more recently, I think it's worth noting, by even conservative jurists like Frank Easterbrook have embraced this idea that in those contested cases, again, in those hard cases that work their way up the appeals chain, that in those cases, there really isn't much law to identify. And so for that reason, courts should stay out. Now, per Frank Easterbrook, the traditional way of implementing that idea, that in these hard cases, courts should simply stay their hand, typically that sentiment is implemented through what Sam and I elsewhere have called doctrinal solutions, right? So rules that tell courts, only declare acts of Congress unconstitutional if the unconstitutionality is obvious or flagrant. Now, as we've written, however, those sort of doctrinal solutions, which are in effect self-restraint solutions, right? It's the court promising not to intervene unless there is clearly identifiable law. Again, as a historical matter, courts, although perhaps for very brief periods, have been willing to engage in that sort of self-restraint, but very quickly, courts abandon that restraint in the service of pursuing substantive ends. Okay, and so for that reason, again, we argue that this sort of doctrinal approach to self-restraint is just a failure. And so instead, what we propose is our approaches like a supermajority requirement, sort of external constraints that in effect act as functional substitutes for those sorts of doctrinal solutions. And here, again, just to come back to this idea that in hard cases, there is no law. Here, the idea would be that, look, unless you can assemble a supermajority, right, whether it's 6 or 7 or 8 or 9 justices, right, unless you can assemble a supermajority, that is a sufficiently hard case where we feel confident saying, look, courts should just stay out, right? There's nothing here that we feel comfortable with courts deciding. This is too contested for us to believe that the court is, in fact, identifying previously adopted legal restrictions. Okay. Now, in terms of, again, pros and cons, on the one hand, so what speaks in favor of the supermajority requirement? Now, again, what we get here is a relatively meaningful limitation on judicial meddling, right? Again, assembling a supermajority requirement is much more demanding than assembling a simple 5-4 majority or 2-1 majority on a Court of Appeals panel. At the same time, it doesn't remove courts from the picture entirely, right? So we still have the possibility of courts assembling a supermajority in what we might think of as like egregious cases of unconstitutionality, right? Cases where there is a consensus, let's say across an ideological spectrum, that what the legislature has done is constitutional. So again, so you have this sort of possibility of judicial intervention in cases where you can't assemble, in what seem like clear cases where you can't assemble that supermajority, but we limit judicial authority in those more contested cases. And for that reason, again, this supermajority approach, at least compared to the jurisdiction stripping approach that I'm going to talk about next, seems, again, comparatively modest, right? It preserves a meaningful role for the Supreme Court, for courts in general, in terms of interpreting the Constitution, determining what statutes are and are not consistent with that document. Okay, so that's on the pro side. On the con side, on the one hand, as you surely know, the current Supreme Court has a conservative supermajority. So at least in terms of that 2/3 rule, right? If your supermajority rule was that 6-3 rule, well, at least in most cases, right, the conservatives would still be able to assemble that necessary supermajority, which I think shows both the limits of the idea of a supermajority, both as a proxy for there being uncontroversial law, right? Because I think it's fair to say that many of these Supreme Court 6-3 decisions seem kind of made up, right? It seems like the court is just making policy, and yet here we see the court able to satisfy, again, at least that 2/3 requirement. Now, again, you could set the requirement higher, could set it 7, 8, or 9 justices, but at least for that 2/3 requirement, the limitations are obvious. And then again, this issue in terms of the politics of a supermajority rule, this issue of building relevant constituencies, right? Again, supermajority rule is a straightforward process. Reform, hard to get people excited about it. Okay, last, third proposal I'm going to turn to is the idea of a supermajority requirement. Okay, and so, or excuse me, a jurisdiction stripping provision. Now, again, so what is a jurisdiction stripping provision? It is just a piece of ordinary legislation that says courts shall lack, or all courts, or the Supreme Court in particular, shall lack jurisdiction to hear certain types of cases. Right, so it just says, again, we're not going to get into like what are the rules for under what conditions the court can rule one way or another. Rather, we just say courts cannot hear this type of case. Now, as a practical matter, we see these provisions all over the United States Code. Here in a really excellent article by Laura Dolbau, who just is about to join the law faculty at the University of Colorado. Laura catalogs the various uses of jurisdiction stripping provisions throughout various federal statutes, noting that in particular, these sorts of provisions tend to appear in national security legislation, immigration legislation, and also in the Medicare and Medicaid context. Or to use an even more recent example, Joe Manchin, somewhat famously, at least in certain circles, inserted a jurisdiction stripping provision into the Inflation Reduction Act, insulating the granting of a certain fossil fuel pipeline, the decision to permit a fossil fuel pipeline, insulating that from judicial review. And so I think those examples illustrate both that jurisdiction stripping provisions are actually quite familiar within our practice, and more specifically reveal that conservatives in particular are actually quite comfortable using these sorts of provisions when it comes to the specific issues that they care about. Right, and so that then invites the question of like, why aren't liberals or progressives doing the same? Moreover, that specific targeted use of jurisdiction stripping provisions by people like Joe Manchin also shows that jurisdiction stripping, perhaps in contrast to those other the other reforms, legislative overrides, supermajority requirements, really lends itself to a statute by statute implementation. Right, so rather than passing, Congress could pass a general statute saying that the U.S. Supreme Court cannot consider any constitutional challenge to any piece of federal legislation, but it can also attach individual jurisdiction stripping provisions just to specific pieces of legislation. And in particular, Congress could attach these provisions to particularly important pieces of legislation. Right, so for example, if Democrats were to adopt the John Lewis Voting Rights Act, or the PRO Act, or the For the People Act, a very straightforward thing to do, a very sort of natural way to protect that important piece of substantive legislation from judicial obstruction would be to include a jurisdiction stripping provision. Okay, now that's in terms of how the jurisdiction stripping provision works. Again, question, can Congress do that, right? Is this legally permissible? And now here, we can turn helpfully to the text of Article 3 of the Constitution, the article that articulates the role of the judiciary within our federal system. And here, happily, there is a quite explicit clause here to draw on, what's known as the exception clauses, which, again, in contrast to for the Supreme Court specifically, the Supreme Court does enjoy what's called original jurisdiction, which is to say immediate jurisdiction, right? So if there is a particular dispute, it goes straight to the Supreme Court, but only in very specific sets of cases, right? So for example, cases involving ambassadors or cases involving disputes between states, right? Those very specific types of disputes, those go straight to the Supreme Court, right? So if there's a battle between two states over water rights, let's say. But outside of those very specific, very few cases where the Supreme Court enjoys original jurisdiction, the general rule under Article 3 is that the Supreme Court shall enjoy appellate jurisdiction, right? Again, hearing the case after some other court has heard it. But the Supreme Court, as a default, will have appellate jurisdiction in all cases with such exceptions and under such regulations as Congress shall make, right? So it's that explicit grant of the authority to Congress to make exceptions to the Supreme Court's appellate jurisdiction that is the basis for jurisdiction stripping legislation, at least with respect to the Supreme Court. Now, what about other courts, right? So that's the Supreme Court, but what about, let's say, federal courts of appeals or federal trial courts? Well, there, again, Article 3 also very helpful in that Article 3 makes explicit that the actual existence of other federal courts, right, whether it's courts of appeals or federal district courts, the existence of those courts is entirely discretionary, right? The only federal court that Article 3 mandates, the only federal court that has to exist under Article 3 is the Supreme Court. And every other court is discretionary. And so for that reason, insofar as Congress has the power to create those courts or not, inherent in that power, or subsumed within that power, it is broadly understood, is the authority to deny jurisdiction to those courts in particular cases. Okay, so that gets us through federal courts. What about state courts? Now there, the sort of standard theory is that pursuant to the so-called necessary and proper clause, which says that Congress can take such steps as it deems necessary and proper to effectuate the various powers articulated in the Constitution. A totally conventional understanding of the necessary and proper clause is that when Congress passes a federal statute, at least, that inherent in the power to enact that federal statute is to deprive state courts of jurisdiction to hear claims under or challenges to those statutes, right? So again, whichever layer of court we're talking about, whether it's the Supreme Court, lower federal courts, or state courts, there are relatively uncontroversial constitutional hooks for a jurisdiction stripping provision. Now, having said that, although almost everyone agrees that Congress can withhold at least some degree of jurisdiction from any court that we can identify, there is a question of, is there a sort of outer bound, right? Can Congress go too far? Is it too much to strip jurisdiction completely from all types of, let's say, constitutional cases? And here, probably the most famous piece of legal scholarship on this is the so-called Dialogue by Henry Hart, where Hart argues that although the exceptions clause unambiguously grants Congress the authority to limit federal court's jurisdiction, the Supreme Court's jurisdiction, he says, nonetheless, Congress must preserve enough jurisdictions to let the Supreme Court perform what Hart calls its, quote, essential role. Now, what does that mean? Great question, right? I think that, very hard to say. And that's an idea that we're going to come back to, right? What is the Supreme Court's essential role? So at least there, though I want to point to, Hart at least says, look, maybe there has to be some limit to the constraints on the Supreme Court's judiciary, but notably the constraint that he finds is a relatively vague idea of, again, the court's essential role. Okay, now pros and cons, right? What do we think about jurisdiction stripping requirements? So on the one hand, at least we might think of a pro of the jurisdiction stripping approach is that it just gets courts out of the way, right? It wholly reassigns the task of constitutional articulation, rights articulation, to more democratically responsive actors, right? So we ask, what does equal protection come to within our constitutional system? If we strip all courts of jurisdiction over equal protection challenges, that task falls upon Congress and the president to decide, right? And through them, the people themselves, right? So too, when it comes to freedom of speech, right? What does freedom of speech protect? What does freedom of speech prohibit, right? Those sorts of questions, those sorts of normative or questions of political morality. Again, through the use of jurisdiction stripping, get channeled away from philosopher king justices and sent to at least comparatively democratic actors, right? And in particular, allow those self-consciously political actors to decide what equal protection means or should mean, to decide what freedom of speech should mean, rather than courts pretending to discover answers to those questions in old documents. Okay. Moreover, if we think about on the pro side here, we talked earlier with those other generic reform approaches, legislative override and supermajority requirements, this difficulty of building political constituencies behind procedural reforms. Here, with jurisdiction stripping approach, that actually sort of solves that problem, right? Because again, if what we're doing is attaching a jurisdiction stripping provision to, let's say, the PRO Act, right? The political constituency behind that is just the political constituency that's behind the PRO Act, right? It's labor advocates and the like, right? So too with voting rights legislation, right? It's the same constituency that cares about voting rights. We try to communicate to that constituency. The only way to insulate that voting rights legislation from judicial obstruction is through the attachment of a legislative override. So again, I think that helps with that political problem. Okay, on the con side, right? What are the downsides of the jurisdiction stripping approach? Now, one at least potential downside here is that Congress is also pretty undemocratic, right? That's a sort of, again, we're talking about sort of democratizing reforms, trying to sort of give power over what the Constitution means, take it away from courts and give it to the people. But of course, insofar as what we're doing is giving power or taking power from courts and giving it to Congress, right? Congress itself is highly undemocratic, right? Owing to familiar problems like partisan gerrymandering, malapportionment in the Senate, the Electoral College on the president's side, right? So that's conceitedly, again, even if we sort of take this decision away from the court, it's not that it's going immediately to the people themselves. Now, important to bear in mind here, though, two things. One is that when we're trying to decide where should decision-making authority rest, we're always making a comparative assessment rather than an absolute assessment. Right. So even if it's uncontestably true that the United States Congress is undemocratic, it is nonetheless more democratic, which is to say more easily pressured by the people than is the federal judiciary. And so in that sense, channeling decision-making authority from the court to Congress is at least a modest improvement. Second, it's important to bear in mind, this goes to thinking about the relationship between, again, judicial reforms and other types of reforms. The judicial reforms that we're talking about here and that we talk about in our work more broadly are decidedly not to be understood as to the exclusion of other democratizing reforms as to other institutions. To the contrary, right? We view this democratizing approach to judicial reform as of a piece with democratizing reforms for Congress, for the presidency. Again, dealing with issues like partisan gerrymandering, the Electoral College, and so on. Okay, so again, that's one potential downside. Now, in terms of, I think, what are in fact actual downsides, though, I think one, again, is just politically that on the one hand, because jurisdiction stripping is the most dramatic reform, it is in turn perceived as the most radical reform, right? We are simply eliminating the role of the judiciary, at least in certain cases, and that can be uneasy. That can make certain more moderate constituencies feel uneasy. In part for the reason that, again, comparing to the supermajority requirement, under a system of under a jurisdiction stripping approach, even in quote unquote egregious cases, right? Cases that where the Supreme Court, let's say, could put together a 9-0 majority, right? If the Supreme Court can't hear the case in the first place, you don't get judicial intervention, even in those egregious cases. Now, it's important to note that although that is at least a potential downside, there's no guarantee that, again, even under a supermajority requirement, that courts will only intervene in cases that we, sort of as a democracy, would actually regard as egregious. But again, that is at least one potential downside. Another sort of practical challenge, at least when it comes to jurisdiction stripping provisions, is that courts historically have read those provisions incredibly narrowly, right? They have really contorted the text of jurisdiction stripping provisions to make them mean much less than the most straightforward reading of that provision, right? So reading jurisdiction stripping provisions to exempt constitutional challenges, for example. That's one familiar sort of really somewhat deliberate misreading on the part of courts of existing jurisdiction stripping provisions, which in turn raises the more general question of, okay, so we've considered various legislative approaches to democratizing the law or disempowering courts, but very easy to anticipate is that courts will resist, right? That we're going to face meaningful judicial obstruction. And so what do we do about that, right? How do we deal with this easily to anticipate judicial recalcitrance? Now, one observation is to say, like, look, this is just a political struggle between Congress and the president and courts. And Congress in particular has all kinds of tools at its disposal to retaliate against courts to the extent that courts are behaving in an obstructionist manner. Although, again, judges enjoy life tenure and salary protections, Congress does have control over the court's budget, for example, or over the court's caseload, right? Could mandate that the courts decide orders of magnitude more cases, right? Increasing the workload for courts, making their life, the life of judges, much less pleasant. In addition, again, this returns to the part one sort of issue that I started with, the question of what is the relationship between disempowering reforms on the one hand and those earlier personnel reforms that I mentioned, and in particular, what is the relationship between disempowering reforms and, let's say, court expansion? Now, I think one sort of way to think that like the one popular way that these different approaches to reform have been understood is as substitutes or alternatives, right? Either you pack the court or you strip the court of jurisdiction. That's one way of thinking about the two types of reforms. I think, though, a more helpful way of thinking about those reforms is instead, rather than as substitutes, instead as complements, right? As complementary reforms that working together help to ensure a more democratic society, right? So, for example, if in addition to enacting various jurisdiction stripping provisions or a supermajority requirement, Congress and the president were to add various justices, perhaps justices more like Justice Jackson, who has made it a recent sort of project to emphasize the importance of respecting democracy and in turn envisioning a much more limited judicial role. To the extent that more justices like Justice Jackson were added to the court simultaneously, right, those justices would then be in a position to uphold the inevitable constitutional challenges to jurisdiction stripping provisions, to supermajority requirements, and so on, right? So we might think that in fact, in practice, implementing these two types of reform simultaneously is the best way to get reform to stick. And just to close out, sort of one last reform, a specific reform that I want to mention, and it is technically a type of jurisdiction stripping, but it's a reform that I tend to think of actually as a personnel reform in effect. And this is the idea of jurisdiction channeling. Right, so with jurisdiction stripping, I mentioned, sort of one, at least the sort of most straightforward version of a jurisdiction stripping provision would be to say that no court has the authority to hear, let's say, constitutional challenges to the Voting Rights Act. Right, now that's one way of adopting a jurisdiction stripping provision. Another, though, would be to say that, no, it's just the Supreme Court in particular that cannot hear challenges to the Voting Rights Act. And in fact, one approach that various legislators have been contemplating recently is this idea of channeling jurisdiction away from the Supreme Court to, let's say, the DC Circuit, right? Let's let the DC Circuit decide the constitutionality of the Voting Rights Act rather than the Supreme Court. Now, in practice, again, I think a jurisdiction channeling of this sort, and you can see based on the motivations, really is a form of personnel reform. And in fact, it really is kind of like a backdoor court packing approach. Right, because what you're doing is just in effect saying like, okay, I don't like the ideological composition of the Supreme Court. I'm going to let the DC Circuit decide this. Now, on the one hand, again, I think this is a genuinely useful tool, right? Again, if we're trying to, if Congress manages to adopt various democratizing or disempowering reforms, one way to insulate those reforms from judicial obstruction would be to channel review to a more favorable judicial venue. So again, I think it's a tool that's in the toolkit that we should contemplate. On the other hand, I think it is important to bear in mind that when we talk about jurisdiction stripping, if our goal is in fact genuine democratization, genuine disempowerment, not just of the 6 conservative justices on the Supreme Court, but rather of courts more generally, jurisdiction channeling doesn't get us there. Right. It just, again, it's a way of finding more favorable judges, but it leaves the ultimate authority with judges rather than with Congress, and in turn, rather than with the people. Okay. And so with that, I will leave you to your group discussions. Thank you so much.
Amazing. Thank you so much, Ryan. That was fantastic. like a lot for us all to discuss in the next 45 minutes or so. A reminder, now is the time to hop off if you are joining an in-person discussion group or participating in one with its own Zoom link. If you stay on this line, then in just a minute or two, you'll be sent to a breakout group. The discussion questions are in the chat, so everybody should have access to those. And then just a reminder to please fill out the feedback form before you log off for the night. Thank you again to Ryan. Thanks for everybody for joining us. And Steve, if you want to send people to their rooms, that would be great.